Hello, and welcome to the April edition of the DVAP Monthly MCLE series. We're happy to have you all join us this afternoon. As a reminder, this session is a webinar, so you will be unable to interact directly with our speaker. However, please feel free to enter any questions or comments in the Q&A box at the bottom of your screen. All questions will be answered at the end of the presentation, time permitting. A copy of the presentation will also be provided to all attendees, as well as the MCLE course number via Zoom. Today's presenter is a dedicated advocate, educator, and legal practitioner with a distinguished career in family law and public service. Chante Brantley is a clinical professor of law and the founding director of the Van Sickle Family Law Clinic at SMU Dedman School of Law. In this role, Professor Brantley mentors and supervises law students who provide critical legal representation to low-income clients in a variety of cases. She teaches the civil litigation process through hands-on clinical practice, guiding students in case preparation, courtroom procedures, and client advocacy. Professor Brantley holds a BS from Texas Women's University, a MS in social work with a concentration in child welfare law from the University of Texas at Arlington, and a JD from the University of Texas School of Law. Professor Brantley holds certifications in basic mediation, family law mediation, and CPS mediation. And I could continue listing all of her great accomplishments. However, for the sake of time, I will pass it on to Professor Brantley. And thank you for being here today, Professor Brantley.
Thank you for inviting me, Marcella, and thank you for that introduction. And thank you for all of the attendees. And let's go ahead and get started. We'll be talking about unpacking the divorce process. And let's go ahead and get started. All right. So the purpose and the goals today is to equip the pro bono attorneys with the tools and the confidence to handle a no kids divorce in Dallas County. And by the end of the session, the participants, you will have an understanding of the forms that are used, the timeline, the court process and procedures, and know where to turn when you need some help. All right. So today, the takeaways, we'll talk about the process in stages. And our workflow and the discussion will start out with how to process a divorce with no children. And as I mentioned, the forms, and then we'll do a step-by-step workflow. And at the end of the day, you'll learn how to finalize the case, and hopefully you'll feel confident about taking a pro bono case from DVAP. So I want to talk a little bit about when you get your packet, you're going to see, some instructions. You're going to see a list of forms and all of the documents that you need to process and advocate your no kids divorce. You will have everything you need in the packet, and all the way from opening, interviewing your client initially to sending them a closing letter. So I want to talk a little bit about just some key concepts and just basic law that you need to know for a divorce with no kids. Of course, there is some residence requirements. This is all Texas law. One of the parties, and it's key, one of the parties must live in Dallas County, or the county in which you're pursuing the divorce. And in this case, in Dallas Volunteer Attorney Program, it's through Dallas County. And no-fault divorces are typically under the grounds is insupportability. There's a community property presumption, and the separate property which is acquired before marriage or by gift or inheritance. But of course, in Texas, we all start out that it's the courts presume that all of the property that has been accumulated is community, but it's a rebuttable presumption. And then there's a mandatory waiting period, which is typically 60 days. There's an exception if there's family violence. And I just want to note that when you're counting the 60 days, you don't count the day that you file. You start with the next day, and then you don't count the 60th day. So typically, a divorce can be granted on day 61, and that's in these cases for no fault, no kids, and if everything is aligned, which in most cases it is in terms of service and all of that, you can achieve finalizing this case by day 61. Name change. A lot of times people are asking for a name change, and under the law, it's usually your name changes back to your previous name, and this is something that can be granted in the final decree. And then, of course, cases of prove up is required. And in Dallas County, you can do a prove up by affidavit, which we call it submission, Zoom, or in person if it's allowed. So let's move on to sort of unpacking the process. So step one, and is, of course, your preparation. You would prepare it like any other case. You want to meet with the client and kind of talk a little bit about the facts of the case. Um, and then the documents that you want to execute, which is going to be very important for paying for the costs, is the affidavit of inability to pay. And that's going to be included in your DVAP packet. And I want to note and emphasize that the affidavit of inability to pay, there is a caption at the top of that document. I highly recommend that you fill it out prior to all of the boxes from the parties, from that it's going to be in Dallas County District Court. All of that information needs to be on it. I recommend when you send it to your client and before they execute it, because what happens if it's not completely filled out once you e-file it, the clerk's office may send it back because it's either blank or it's doesn't have the necessary information. So just as a caution, make sure that you fill it out before you send it to the client. And then additionally, to get the divorce process started, remember the affidavit of inability to pay, that's what's going to pay the filing fees. And typically it also covers the service by a constable. And then you get into initiating the divorce by drafting your petition. And DVAP had some very good templates that are included in your packet. Uh, for the most part, it's fill in the blank. And so you're going to draft it and you sign it. You're going to e-file it. And then, of course, once you e-file it, there is in Dallas County has a standing order, and you would typically see the standing order either in the packet. And I always tell attorneys that you want to make sure you look up in the district clerk's office. The clerk's office usually have all of the documents. And in this document in particular is the standing order. So you want to make sure you have the correct standing order, because that is the document that you're going to attach to the petition. And the standing order is just basically an order which tell the parties how they are supposed to conduct themselves during the divorce process. And then also you're going to have in the packet, if you are seeking legal notice and you want it, if you don't get a waiver, you need to get a citation. Then, of course, when you're filing the petition, you can request a citation so that the person could be served by Dallas County um, Constable's office. And I also want to mention what it says, use only the last three digits of someone's social security number or their driver's license number. Of course, just like in any civil case, There is information that we're not supposed to disclose, that it needs to be redacted. So, of course, we don't use the entire social security number or confidential information. So we just use the last three. And you will see this in the petition where you need to enter the last three if they have a social security number or if they have a driver's license number. Of course, when the documents are filed in, just like in any other civil matter, they're randomly assigned. And Dallas County has seven family courts, and then the family courts have associate judges. So a total of 14 judges in Dallas County. And one of the here I have highlighted that's very important. This is something that I emphasize in my teaching. Make sure you read and follow the court's policies and procedures because they may be different. Most of the policies and procedures are posted to uh, Dallas County to their website. So you definitely want to look at their policies and procedures, kind of get a sense of when they have prove up hearings, whether they allow you to do a prove up in person over Zoom, whether they're encouraging you. A lot of the courts are encouraging that if it's an agreed, that you do it by submission, and that's the way you bypass anybody having to travel down to Dallas County or Zoom or whatever. It's just something that you submit and you ask the court to submit all of your documents by submission. But we'll talk about that a little bit more. All right, step two. So we got the petition drafted and it's nice and it's ready to go and you're excited about it. You've e-filed it, you've got it accepted, and then you have to do service of process. Basically, the respondent has to be notified of the lawsuit. And in most cases, the best option is the waiver of service. And when you get your DVAP case, there'll be some notes in the case file whether or not the petitioner or your client has said that they believe their spouse would sign a waiver of service, or they'll tell you maybe they won't sign a waiver of service, but I have an address form, so I know how to get them served through process and through the constable. Um, and one of the things in terms of the waiver of service, it must be signed in the presence of a notary, and it can't be signed prematurely. So it has to be signed. If you file your petition today, you want to wait until tomorrow before the waiver of service is executed. Um, and so that's the best option in most cases. That's ideal, and you will have a waiver of service. But in the event that doesn't work and you don't have a waiver of service, but you have an address and you want to get them personally served, of course, it's required if they're known and there's no agreement. You can have the constable or the sheriff have them personally served. And here, this process, if you are not sure, for say, for instance, once you file your petition and you haven't requested service because you're thinking that you're going to get a waiver of service and it doesn't happen. So after the fact, you can request personal service. Dallas County, you can submit a cover letter which requests service of process. And once you get it accepted, then the clerk's office will take it from there, meaning that they will send it to the constable, and then the constable will go and have it served. So it's just like in any other civil case in terms of service of process. And then for some reason, you don't have this doesn't work. Option one doesn't work. Option two doesn't work. And you know that the respondent, lives there, but they're kind of avoiding service. Then you can go and ask for Rule 106, which is alternative service, to maybe have them served at a place where it's known that they actually live. And then you can ask the court um, to allow you to either attach it to the door, leave it with somebody there that's under I think it's at age 16, I want to say. And so, but here I noted if you get into this area, option 3, you can always ask Catherine or Kristen about the motion, because you got to file a motion, just like in any civil matter, asking the court to allow and to grant you permission to serve alternative service. And also email, some courts don't like kind of using email, but email is an option as well. So all of the alternative methods that's under Rule 106 apply in this case as well. And then all of these, option 1, 2, and 3, is based on the respondent either address or whereabouts are known. Here is an option 4. This is service by posting. This is when the respondent's address is information, when the whereabouts are unknown. And so but first, there has to be diligent efforts made to locate the respondent's whereabouts. And sometimes that's a longer process, but some of the basic ways and methods that we use to try to find someone, checking social media, looking at Dallas County records, last known addresses, last known employers. So the court is going to require diligent efforts to be made. And then, of course, that is once you submit your documents to the court, your motion and your affidavit, and showing that you have made the diligent efforts. In the court, if they decide that those efforts are sufficient, they will allow you to do um, service by posting, and that is just posting one day, posting at the courthouse. And once it's posted and it has ran it the amount of time, and you don't have an answer, then you move into a default. So the options are available just like in any civil matters. The best option, starting with the waiver, and then hopefully personal service. All right, so now we got good service and we're kind of waiting. There is a waiting period, of course, in order for the respondent, after they get served, it's 20-day, the Monday next. So it's typically sometimes going to be around 28 days. It just depends. If they get served today, you start counting. And the key I want to mention, if the 20 days land on a Monday, you still have to wait the Monday next. So just remember that Monday next is very important, so that your the service in the default can be right, and the answer period has passed before you move forward. Because after the answer period has passed, you can proceed with a default divorce. But just say, for instance, there's an answer. It's not a waiver. They get served and they have an answer. They file or they make an appearance, then you're going to need to involve them in the lawsuit. So after service, and you still remember there's a 60-day waiting period, but from the time of filing, if there is no waiver for a waiver that you don't have to wait 60 days, then you start preparing the final decree. And yet again, DVAP have some templates and the forms that you need to file to draft the decree. And based on the type of service that you have, if you are, say, for instance, there is an agreement or a waiver on file, then you can do a decree by affidavit, or you can do it in person, or you can prove it up by uh, over Zoom. So it all depends on what court you're in. Um, but in the packet, you will see a decree, a final decree, if you want to do it in person or final decree, if you had to do, if the service was by posting. So that's a good thing about the packet. Based it, everything sort of kind of matches. So your petition, how you got service achieved, based on how you got a service achieved, then you're going to choose the right final decree that you need in order to submit to the court for consideration. All right. Step 5. So we got the final decree, we got things filed. Now we are wanting to kind of finalize the divorce and move into the prove up phase. And we got to be thinking about, okay, when can I finalize? When, what all needs to be aligned before I finalize the divorce? So you can finalize when? 60 days. Remember, the 60 days have passed. And this is the key based on, and one of the following applies. So the respondent was served but did not file an answer. And the return, here's key. If they didn't file an answer, the return of service has to be on file at least 10 days. And then you got to think about, I want to just pause here, the return of service on 10 days. This is actually if the respondent was served. You got to check with some courts, even if it's a waiver of service. The waiver of service, they may want the waiver of service on file 10 days. And so if the waiver is, the return of service, and all of this information can be found on Dallas County online portal. You can follow your case and all the actions in the case, because sometimes you may get a notice by e-file, but sometimes that may be delayed, but you can look online and kind of follow the activities in the case. But what if the respondent signed a waiver of service? And the respondent filed an answer or made an appearance, then if they filed a waiver of service, typically you're going to give them they'll sign the final decree. And then that's pretty much all you need. If they filed a waiver and they said that, hey, I want to review the final decree, once that's signed, you can go ahead and file, and you're pretty much kind of ready to prove up your case. But even if they filed an answer and they agree to the final decree, they can go ahead and sign the final decree, and then you can submit that to the court as well. And then also, so once you have filed all of your documents and you're ready for the prove up because the 60 days has passed, you got all the signatures on the final decree, the return of services on file, then you're ready because the court coordinator, if you want to do a prove up in person over Zoom, they like for those documents to be filed and accepted, because once they're filed and accepted, this signals to the court that you're ready to proceed. And so they may, in our case, in the clinics, we like to have the students an opportunity to present a case before the court. So we usually try to see if we can do it by Zoom, but sometimes that may not work, but depending on the court. So we'll go ahead and do it by submission. But it all depends on what court and how you would like to prove this case up. And I will say that probably if it's a DVAP case that you're taking and you want to just, submit it by prove up, that's definitely an option for you. If everything aligns, that may be a way that you can free up some of your time and be able to take the case pro bono and still achieve the same result by getting the person divorced. But at anything that you do when it comes to these cases, make sure that you're following the court's policies and procedures. And then sometimes if it's confusing, you're not really sure. It's okay to send the court coordinator an email and maybe ask some questions. And you can also use DVAP resources as well. All right. So here let's just talk a little bit, in which I kind of weave some of this in already in terms of the prove up procedures um, and the process submission. Here, this is what the ideal case. If a waiver of sign, you got a final decree. You can prove it up without any going to court and just asking the court to consider it on submission. And one of but keep in mind some of the documents for a submission. You got to have a final decree, prove up affidavit. And the prove up affidavit is basically, it replaces prove up questions, the questions that you would typically ask your client in court. They submit an affidavit. And so the affidavit they submitted, it has to, to be notarized. And also you want to submit the Austin form. We call it an Austin form, but I think it has an official name, a long name that I can't recall right now, but in practice, we call it the Austin form. So if you hear the clerk or anybody ask where's your Austin form? It's something that we as practitioners name because it's actually a form that goes to Austin, Texas, to Vital Statistic, that basically tells them that somebody got a divorce and they keep the stats on it. And then by submission, if you do by submission, you want to, in the comment section, you want to, after you e-file your documents, and e-filing in Dallas County, let me just say, we use the all documents or lead documents. In terms of your final decree, and if a code that you looking for, if it's not there, choose no fee document. I think that's what it's called. Um, and so for submission, in the comments, you want to ask the clerk, please submit this to the judge's queue for signing or for consideration by submission. But I also will say you can put it in the comments, but I would recommend with a follow-up phone call to the clerk's office, once it's been accepted, a follow-up call to say, to check to see if it was submitted to the judge's queue. Because sometimes it's automatic, but sometimes perhaps for whatever reason, maybe they didn't see the comments. And so it's always okay to follow up with the clerk's office and ask if they can go ahead and submit it in the judge's queue. And for the most part, I usually typically, give the judges, a week before, you're calling and seeing what's going on after you've called the clerk and you are satisfied that it's actually in the judge's queue. Eventually they'll get to it and they'll sign it. Here lately, I get emails that it's been signed, and then you get a copy of the signed order back. And so that's the process typically for submission. But one of the things I want to say, that if you do it by submission, we used to do it old school. We're there in court, we're finalizing everything, we get our certified copies right the same day. But that doesn't happen if you're doing it by submission. And I think typically they'll give you a free copy if after your submission, if you're there the same day. But after the next day, it may be a cost. But I would check with DVAP to see if they're able to get a certified copy, or if there's another method. In the family law clinic here, we have an account that we submit based, because it's pro bono. We usually submit and ask for a certified copy. And now they're sending certified copy. You can literally get a certified copy of a final decree by email with all of the bells and whistles that said that it's certified. So, the days of going down to the courthouse is probably not as necessary, but So that's a real, I would say that's a real plus for Dallas County being able to submit um, certified documents by email. All right, so we've done a submission. If that's something that works well for you, that's great. If you wanted to have an opportunity to for record in cases, and especially in default cases, a lot of times the court want you to make a record, meaning hold a hearing of some form. And so you can contact the court coordinator to get a hearing, look at the policies and procedures to see when they hold them. If they're allowed, you can just pop up at a hearing like we used to do in the old days. You can do that, but I would definitely check with the court policies and procedures in terms of how they will allow you to hold a hearing, whether it's in person, but typically it's Zoom. All right, so let's just finalize it and kind of talk a little bit about the stages, sort of that I kind of mentioned what happens. You have your intake, filing, legal notice, service, has been achieved. You're kind of waiting and monitoring. And while you're waiting and monitoring the case, you're drafting your final decree. And then you're determining how you're going to prove it up, whether it's going to be by submission or you need to be have a record, and whether that's going to be over Zoom or in person. And then in terms of the timeline in family, and these family law cases that are divorces with no kids, 60 by day 61, you're pretty much, you can get things achieved. But you kind of thinking about, okay, the service, you remember I said there, once they serve, there's an answer period. Um, and then if there is no answer, by the time it's time to prove it up, they never answered, they never appeared in any hearing or anything, then you have a default. But even with a default, you still have to wait that 60, wait till the 60-day has passed in order for you to prove up your case. And then just remember, the 10 days, you need to make sure that if they're served, that the return of service is on file. And typically the return of service, once the constable serves, they are usually pretty good about going ahead and filing the return to make sure that it's on file. All right. And I think that in terms of having an understanding of the full process, so that when you talk to the client in the beginning, in the initial stage, it can manage some of their expectations, and because a lot of times, they think, well, there's nothing. We have nothing. We have nothing. And so just because we have nothing, they think that it can occur overnight. But of course, there are processes in place. So having that big picture and explaining to them initially is going to be helpful with managing expectation, and then kind of making sure that you're meeting the deadlines and avoiding any kind of delays. Lastly, I want to talk a little bit about the resources that are available under for free e-filing. For the most part, e-filing through texascourts.gov. And then another resource is the Dallas County Clerk's Office, their main number you can call if you have some questions about documents or even the process. Of course, the clerks can't give you legal advice, but they'll give you information about the process, and then the DVAP, the waiver, in any other forms, they are available in the packet that is sent to you. And then the DVAP mentors that I mentioned, and of course, here's my email. I'm available if you send me an email. You have any questions about this process, you can email me at cprox@smu.edu. And if for some reason you forget, you could just Google Shantae Brandley, and our emails, I believe, are linked to our faculty profile. Thank you for listening. And right now, I'll stop and entertain any questions, and we can discuss the process further. And I'll hand it over to you, Marcel. Thank you.
Thank you, Professor Brantley. So let me go ahead and open the Q&A. Um, and the first question, um, and this is regarding if the Monday after 20 days is a court holiday, is the deadline the following day, Tuesday, or does it fall on a different date?
It's the next business day.
Okay. Um, and this is a good question, and maybe you can expand a little bit more, but how does it work when the divorce is contested? How does this skew the timeline?
Oh, that's a really good question. Just say for whatever reason that you get in the contested phase of a divorce, then the timeline is a little longer and the process is a little longer. Just say, for instance, if there can contesting some property issues or whatever they're not following, they file an answer, or they decide that they don't want to sign the final decree, then you have to set the case. Typically, you have to set it on the pretrial docket and have a pretrial hearing. Let the court know, okay, what are the issues? What are we contesting? The judge is going to say, okay, how much time you need for trial? So you have to, at the end of the day, if it's contested and no one is signing the final decree, you have to take it to trial, or it can be a bench trial for the most part, so that the judge can decide. But how you get to the trial phase, you got to have a pretrial hearing, and at the pretrial hearing, the judge would give you a trial setting, and the rule of the trial has to be set more, 45. You got to give the other side at least 45-day notice. And so once you get the pretrial order, it's going to list when your trial is, when your discovery is due, and all of whether you have to go to mediation. And so that's how what the process looks like when it is contested. It's a little longer.
Perfect. Thank you. I don't see any additional questions in the chat. So while we give a moment for anyone that wants to submit a question, I just entered the MCLE course number into the chat for everyone, and I can say it aloud as well. And that number is 174-317-744. Again, that is 174-317-744. So please take that number down and self-report your MCLE credit through your State Bar of Texas profile. Let me go back to the Q&A to see if there's any missed questions. Okay, here's another one on contested divorces. Is it mandatory for the parties to submit an inventory?
It depends. It depends on what court you're in, but typically an inventory, and then what the issues are. I'm thinking that you have a uncontested divorce. Typically, what are they actually fighting of? What property do they have that they need a whole inventory and set up what the value of the property is? So it depends on what court you're in, but typically, yeah, an inventory is required. But always look at the policies and procedures. And one other thing I want to mention, that based on the issue, like if you just have an issue that you think that's only going to take maybe an hour or maybe 2 hours, the court may say, okay, well, I will not require you all to go to mediation, because it sounds like you don't need a lot of the court's time, to determine whatever it is that they're fighting over. So a lot of times contested, it still you look at what it is that you're actually fighting over. And in these cases, if you're receiving pro bono services, there shouldn't be a whole lot of property things that you should be fighting over. So I want to encourage you all that for the most part, don't want to say that it won't move into an uncontested phase because we've had it uncontested just because somebody, they really wasn't fighting over anything. The other party just didn't want to get a divorce. So it just all depends. So I want to encourage you on these cases that you may not get into an uncontested, but if you do, you can still simplify the process by determining exactly what it is that they're really fighting over. And that's just using a limited amount of the court's time to get it resolved.
Perfect. Thank you. All right. I don't see any additional questions in the Q&A. Um, but thank you, Professor Brantley, for being here and giving us a wonderful how-to guide on how handling these simple divorce matters. This session, as I mentioned, you will receive a copy of the PowerPoint for all attendees, and then we are recording it. So if you do take a case through our program, and hopefully you do, we can provide you with the link to rewatch this presentation. And of course, it would also include Professor Brantley's contact information, so that if you have any specific questions regarding the process, you can reach out to her as well. Um, Seeing no more questions in the Q&A function. Again, Professor Brantley, I thank you for being here this afternoon. I thank all attendees for being here as well. And we from DVAP wish you all a great rest of your afternoon.
Thank you. Thank you, everyone.
Bye, everyone.
Bye.